Good afternoon to all, and welcome to today's webinar on fintech, investor, and consumer protection, largely from the US perspective. We have a distinguished panel with us today to give you perspectives on these issues. So my name is Chiu, and I'm a member of the UCL Centre for Ethics and Law that is hosting the webinar today. I will first introduce our panel of speakers and then give a brief outline of the proceedings for today. So our anchor speaker today is Professor Jeff Modisett. He has a long and illustrious career in various capacities. He's currently visiting UCL on a Fulbright scholarship from UCLA. Professor Modisett was a prosecutor, a federal prosecutor in the 1980s, and he's done some very spectacular cases, including successfully prosecuting Mike Tyson. He was also state AG in Indiana. Following that, he's had a stint of private sector practice as well, in terms of being a chief legal officer for Loyal3, a fintech startup in San Francisco, as well as practice at Denton's LLP. In terms of Jeff's experience, he's had extensive experience in relation to this area of fintech and consumer protection, and he'll be speaking mainly about the AG's experience in terms of how enforcement-led regulation helps to pave the way for policy in relation to consumer protection where financial and technological innovation is concerned. He's assisted in the resolution of numerous complex series of litigation, representing clients including Facebook, Oracle, Yahoo, Airbnb, etc. So Jeff's extensive bio is available on our webpage for you to peruse. We also have a panel that Jeff has brought with him today, and we are very privileged to have Chris Kelly as well as Brian Sullivan with us. Chris Kelly is a Silicon Valley entrepreneur, attorney and activist. And from September 2005 to August 2009, he serves as Chief Privacy Officer, General Counsel, and Head of Global Public Policy at Facebook. And relevant to today's talk, he's also been a candidate for California AG. More recently, he's become an investor in entertainment and technology startups. Chris is also a co-owner of MBA Sacramento Kings and currently runs numerous funds dedicated to investing in blockchain and crypto activities. So we'll have a very interesting perspective from the industry. Brian is founding partner of a boutique law firm in California, where he has practiced corporate and securities law since 2006. Previously, Brian spent 13 years at a major international law firm advising on securities, commodities, and corporate matters, including public offerings, private placements, hedge and venture funds, and securities and commodities industry regulatory matters. And Brian graduated from the College of University of Chicago with the highest honors and earned his JD from UC Berkeley. So we are very pleased to have our panelists with us today. And today's proceedings will be as follows. I'll hand over to the floor, and I believe that Jeff will start off with an introduction, followed by Chris and then Brian. And this will take about 30 to 40 minutes. Following from that, we'll have a Q&A session. So for members of the audience, please feel free to send in your questions at any point in time throughout these proceedings using the Q&A function. Co-hosting with me will be Dr. Alan Brener, who will be entering shortly, and he will be moderating the Q&A and taking the questions that are submitted through that function to our panelists later. So without any further ado, shall I hand over to Jeff?
Well, thank you. Good afternoon to everybody, and thank you, Professor Chiu. Very much appreciate the introductions. And I hope we didn't shortchange either Brian or Chris in the introductions. They both have long and illustrious careers, and I'm sure it'll come out during the presentation or during the Q&A. But thank you for convening this webinar, and thanks to everybody else for joining us in this discussion. Let me just set the stage, if I could, with our discussion here today. So when we talk about fintech, we're talking about the fusion of technology and financial services. It kind of covers everything from crypto and AI-driven trading to app-based investing, crowdfunding platforms, and digital payments. And each of these is shaping how money moves, how capital is raised, and how consumers engage with finance. And as you can imagine, this is somewhat challenging. I mean, the laws tend to be technology neutral as written, and that's a good idea in theory, but it gets kind of messy in practice. And so one of the core questions we're going to address today is exactly how do we protect investors and consumers without strangling innovation? I think that's kind of at the heart of the US financial policy today. So one of the reasons why this gets to be somewhat complicated, and I'll just touch on this by way of introduction, is that in the US we have what I would call anyway, regulatory fragmentation. As you're going to hear shortly, we don't have one single financial regulator. We've got a mosaic. So let me start. I'll mention the SEC, the Securities and Exchange Commission. They oversee securities and investment markets. As Brian will probably talk about, it's also the home of the Howey test, the rule that says that if you invest money in a common enterprise, expecting profits from someone else's efforts, you're dealing with a security. We also have the Commodities Future Trading Commission, the CFTC, which regulates commodities and derivatives. And so they classify Bitcoin and Ether as commodities, not as securities. We also have the Consumer Financial Protection Bureau, the CFPB. That covers retail credit, lending, payments. Though under the current administration, it's taken charitably, I'd say, a lighter touch. And then we have our banking regulators, the Federal Reserve, the OCC, FDIC, and they each govern different types of banks and deposits. And finally, we come to my area, which is state attorneys general, and they use their broad consumer protection and anti-fraud powers, kind of fill in the gaps of federal regulatory agencies. And we'll be talking about that. So each agency finds that innovation kind of tests what neutral legal standards really mean. I mean, is an algorithmic trading bot the same as a broker? Should they be traded the same? Or should crypto wallets be treated the same as bank accounts? That's one of the issues we'll be looking at today. And it's no wonder that fintech often falls into this regulatory gray zone. And I should mention that as administrations change from Democrats to Republicans or vice versa, we experience what I call regulatory whiplash. At least recently, it seems like every 4 years, the pendulum swings from tightening the reins to cutting them loose. So that's why today's session is going to blend these three perspectives. Chris Kelly's going to start. He's going to bring us the investor and innovation viewpoint from the blockchain and AI venture capital world. Brian, who's going to talk about the federal regulatory and SEC perspective, and then I'll wrap it up with the state attorneys general perspective. And so our effort here today is to interact to balance innovation and investor protection in fintech. And with that, Chris, let me turn it over to you for your insights.
Thanks so much, Jeff. I come at this from a variety of different perspectives as someone who's taken the role as a regulatory lawyer over time, but who is primarily an investor at this point, and have invested in a number of different financial services companies, including Chime, Loyal3, and a number of operations in crypto, where my current company that I angeled called Alchemy is the primary backend for Polymarket, which is one of the the betting apps that kind of betting apps, the prediction market apps, where people can buy smart contracts on a number of different things and a number of different propositions, and that's scrambled the regulatory environment in America over gaming and gambling as well, not just fintech. But the operation of a number of these companies and other things that have come to the fore. I'm also an investor in public.com, which is one of the kind of neo operations that is offering easy financial services by app to the public in America and around the world. It's a competitor of Robinhood. and a number of other, sort of, of these offerings that are out there. Robinhood has been offering even tokenized stocks in Europe at this point. So there's been some interesting things that they haven't been able to do that regulatorily in the US yet. Um, the whiplash that Jeff talks about is very, very real, because in the U.S. we went from and Brian will get into this, I think, extensively. Um, we went from a very, very heavy regulatory regime, particularly through the Securities and Exchange Commission in the prior administration, to a relatively deregulatory regime, where and a very hands-off approach, where even the president and his family are participating extensively in a number of different crypto-oriented offerings. Presumably those are all okay under existing SEC enforcement operations under Paul Atkins, who's taken over for Gary Gensler as the former chair of the FTC. The layers that Jeff talks about in state enforcement, down sort of at the filling in the gaps, as he described, is quite accurate. Although the fact that state AGs have a lot of different perspectives on this, that they're generally a group under the Republican administration that will say that whatever the Trump administration in Washington is doing is okay, and Democratic AGs are taking some different takes on this over time, and I'm sure that Jeff will get into that as well. In Washington, with the takeover of the Trump administration, there's been quite a focus on promoting innovation instead of a consumer protection role here. The naming of David Sachs as the White House sort of crypto and AI czar, with a deputy who was originally working for the administration but has now gone to work for a stablecoin manufacturer called Tether, emphasizes that this is going to be a very sort of deregulatory. And I don't think and I don't mean it necessarily as an insult, but as a free for all right now. There are a lot of different things going on in this space. I invest in this space largely because I do think that there's incredible innovation happening. And that the prior administration had really gone too far the other way in terms of cranking down all sorts of things that actually could be very, very beneficial to the financial system, declaring that everything is a security, and including and implying that things that are collectibles like baseball cards might even be securities under their interpretation of what's called the Howey test, which is the American test for whether or not something is a security. Jeff outlined the basic elements of that test. But the innovation that's going on in the blockchain and crypto space is quite extensive. That the ability of networks to get up and running, the operation of Bitcoin and Ethereum globally, and other both cryptocurrencies, but also just blockchains that are aiming to record transactions. For those of you who are less familiar with crypto, it's not primarily a token or a currency provider. It's actually primarily an underlying distributed ledger technology, which in and of itself is an incredibly innovative insight into the way that financial services works. Bitcoin is the most prominent network on which these things run, and it does have a token that has a set amount of Bitcoins that will ever be generated at 21 million, and that creates a scarcity that leads to the price spiral up, so upswings that you see. Ethereum is more free floating and has more complexity to that, but also has a lot more capabilities in terms of allocating global compute, and plays a number of other roles here. One of the things that we're seeing across the board is the taking of original things that are core financial services and putting them in blockchain-oriented environments so that you can move things quickly around. The most prominent operation for these right now is in stable coins, and most of which are denominated in the US dollar at this point. And so Tether, as the largest provider, has the largest market cap. USDT is the token that they peg to the dollar, and they do that through the management of holdings of treasuries that are one-to-one with the value of the dollars on the network. And so as people seek to buy more Tether and more stable coins, they have to add treasuries to the stack that backs them. They've started to get a little bit creative in this area, and added other things like 10% of Juventus, the Italian soccer team, and a number of other plays as values, and that actually provides some insight, I think, into the way that financial backing of these stable coins will evolve over time. And I'm involved in a project that sort of takes that insight and tries to apply it more across the board. And it's a nice combination of the NBA world and the sports world that I'm operating in now, and the crypto world as well. But we have to watch very carefully as to whether or not that's going to be seen as a security over time, and operate within the rules as they exist. But the rules have gotten a bit more flexible at this point. There are incredible operations that are going on in the space, and the technological fervor that you hear about artificial intelligence operating on these networks is very real in terms of the way that it operates. And I've been developing some insights. In fact, later on this morning, I'll be on a call about a potential investment that is looking to get out of the upward spiral of everyone expecting more and more compute and more gigawatts needed to operate these bots online, and to do the type of trading that's done in traditional financial services industries, trying to grab some insight from the human brain and the way that it starts to operate in this area. So there are incredible sets of innovations going on in this space. It's a very exciting place to operate. Now, until the innovations started to be more properly, I think, seen as great sort of operational potential advantages for America as a hotbed of this. The prior SEC under the Biden administration was quite involved in quashing a number of these things, and in operating in a way that actually pushed a lot of innovation offshore. The changeover in administrations and the coordination issues that the Trump administration has created under David Sax's office, and in a number of different areas, through the appointment of Paul Atkins as SEC chair, through the new appointment of a CFTC chair that's also very sort of deregulatory, very allowance oriented, has led to a lot of innovation in the U.S. Now, as a traditional financial services capital, obviously London has seen quite a bit of this innovation on its own. Other hubs that have developed are in Berlin and in Singapore, and somewhat in Hong Kong, which is where Binance was originally founded and operated. But Binance is the world's largest centralized exchange. Changpeng Zhao CZ was just pardoned by Donald Trump, which I think bodes for the predictive market should be betting hard on Binance going into America in a significant way in the very near future. So there is a great degree of regulatory uncertainty in all of these jurisdictions, that there have been comprehensive attempts, including by the EU, to provide a framework for digital goods. And obviously, as a Brexit driven thing, the UK has to do this on their own, but still trying to coordinate, I think, quite markedly with the European Union on this. There's a variety of operations in the unfree world that are also going on in this space. I think Russia is going to be too distracted to do much in the space at the end of the day. But China obviously has been very active and has swung back and forth between allowing for a lot more movement in the space, and using letting financial services companies experiment a bit with crypto and blockchain oriented environments in China. But generally speaking, wants to be very aggressively controlled, including likely offering and issuing a central bank digital currency pegged to the yuan. So I think you'll see these over time, these different models, flourish. Now in America, with the changeover of administrations, I think that there's been a sort of let a thousand flowers bloom type of approach, And of course, I do think that this is in part because the Trump family, through World Liberty Financial and a number of other providers, is very active themselves in the space and sees the possibility of huge profits, the Trump meme coin, and things like that. But I also do think that this is not a complete regulatory retreat at the end of the day. I do think that there will be enforcement actions against people who are scammers, and they will be drawn to this space, inevitably, just as they are to the traditional banking system and to a number of others. But the overall message that I want to convey here is that this is seen as an incredibly innovative space. The U.S. is open for business in a way that it hasn't been previously under the administration, and that will create a number of situations where innovative regulators are going to need to step in and fix market dislocation and other things that are caused by scams and fraud, and also through the possibility of destabilization of a number of different systems. We in the U.S. we've had a centralized exchange that got very big in the U.S. FTX go down to fraud. And an action taken against the CEO and the imprisonment of that CEO. I do think that will probably continue under this administration, even though CZ has been pardoned now. And there will be actions taken by this SEC and by other operators to enforce regulatory rules. But the interpretation of the rules is definitely looser. It is a more allowance-based culture that's been created by the Trump administration vis-a-vis the Biden administration, as opposed to the Biden administration. And that is, I think, on balance, a good thing, and in a way that innovation may have been stifled before, but it's not now. That being said, the opening of these floodgates for everyone actually means that some people who would do consumers harm or seek to profit from them in ill-gotten gains ways will actually operate in the blockchain and crypto environments, and as in neobanks and the way that different financial services are being offered. So smart regulators getting smarter over time will allow for enforcement actions against those, while protecting the possibility of innovation over time. So with that framing, I'll be available to participate as Brian and Jeff continue to go through these conversations and the state of things from a regulatory perspective. But I'm excited as an investor in the space about the innovation that's going on. And I think that we're kind of off to the races about rethinking the way that financial services operate. The operating thesis of my fund is that blockchain-based systems will replace almost all financial rails as they exist, and provide for new ways to generate yield on investments over time, and that is something that we should be primarily excited about instead of fearful of.
Thank you so much, Chris. That was great. Brian, can we turn to you now to help us with all your experience as a securities lawyer?
Absolutely. And let me just say again, that was great, Chris, because few people have your perspective, obviously, operationally as to what's going on. I'm basically in agreement, by the way, with most of what you said. I just want to maybe do a couple of pushbacks on kind of minor things, which is, it's true, Trump is Trump, obviously, right? And we all know that. Remember, though, that Trump was actually very hostile in his first term. I mean, Chris is
absolutely accurate. Yes.
Yeah, most people don't remember that.
Yeah.
He actually, if I remember correctly, he called it a scam, right? This thesis then. So now he's been exploring it. So he's learned about it. In fairness, I mean, he's a smart guy, even at his age. He's learned about it. Things like the pardoning of CZ, the founder of Binance, that's unfortunate. That was unnecessary, because that is not something like a Coinbase, years-long investigation and suit, or a Ripple, where Gary Gensler, the former head of the SEC under Biden, is challenging these companies, and they have very smart internal counsel, very smart CTOs. These are quality companies in a new space, torturing them on the basis that, hey, you guys are trying to sell unregistered securities subject to registration of the Securities Act. So That was not the Binance problem. The Binance problem, and again, I'm not an expert on it. You may actually know more about it, Chris, but it always seemed to us that was fairly close to an FTX Sam Bankman-Fried thing. Because again, what he went to prison for was money laundering and failure to comply with US sanctions on terrorists and things like that. Classic bad actor behavior. So to pardon a guy like that because he's in the crypto space, Trump is sending the wrong signal. I'm sure Paul Atkins, the current head of the SEC, didn't go for that. You know what I mean? And what's he going to do?
Yeah.
But the adverse side of that, Chris, is that, guys like Paul Atkins, guys like Sachs, the so-called AR and cryptos are, guys like Mike Sully, who's the, if I remember his name correctly, I know his history. In fact, he's a partner from Wilkie Farr. That's where he's coming from immediately now, one of our leading Wall Street law firms. These are pure technocrats. These are pure technocrats who are all bought into the potentiality, maybe the revolutionary potentiality of both blockchain and crypto, right? Just to focus on that huge aspect of fintech. I think the rest of fintech, and I'll get into that quickly here because we have limited time, is probably those regulations are probably going to stand. We've already seen signs of that. But as we know who are in this space, as Jeff said, regulatory fragmentation, the turf wars, the illogicality of applying the Howey test as to what's a security to things like decentralized finance, just absurd. Jeff, you'll remember when we were representing clients, the amount of time we spent with them on just trying to structure something so it best at the time satisfied just the hints from the really smart people. This is the way to go. So it's not a security subject to registration. Waste of time, a hindrance to development of business. These pure technocrats want to revolutionize the regulatory framework. They're not looking to take away the fintech protections. They're going to be on top of Robinhood when it missteps, right, under regulation. Best interest, which is it actually was adopted during the Trump administration. People think that it's a Biden administration. It was actually adopted, lay fallow until 2024. It's adopted, it became effective in 2020. Then in 2024, under the Gensler regime, they started with some egregious cases applying it. The Trump administration has continued to do that. Now, the big case with Robinhood was actually a Massachusetts state statute. Jeff, you know this, where they have much broader standards like unethical and dishonest conduct of brokers. That's just an open sieve, right? But I have no doubt that the Paul Atkins-led SEC that Trump has in place right now is going to continue to not only do that with respect to the broker standard of conduct, which is now quasi-fiduciary, I guess is the way. Some people talk about it as being fiduciary, like with respect to investment advisors. I don't think it is. It's not intended to be. And it has cleaned up. Anyone who's a consultant in the broker-dealer US space will say that regulation cleaned up de facto, even though it's kind of an awkward regulation. Everyone's compliance, all their procedures. They hired third-party consultants at great cost to institute these things. It's done a lot to clean up the business. The new SEC under Trump is going to continue to, in egregious cases for sure, the most recent case being they led investigations. Most of it's turned over. Jeff and Chris, you know that. We have a funny structure here where self-regulatory organizations operate as delegatees of the SEC. Every registered broker-dealer in the United States basically has to be a member of what's now called FINRA, which is a self-regulatory act. So it's a kind of funny thing where the wolves are, kind of policing what's going on in the chicken coop. Although I would say it's worked well in our country over my lifetime as a lawyer, 40 years or whatever, it's worked well, but that's generally handled. And of course, that regulation BI is also something that the self-regulatory organizations have to, uphold. It's worked well, but the SEC intervened with a recent case in which high yield bonds, they're called L bonds, were sold to a bunch of impecunious elderly retirees with no investment experience, averaging 20 to 50% of their small nest eggs in these ridiculous investments. The company goes upside down. The new SEC brings the matter, has a settlement. Unfortunately, these settlements are kind of small. That's one thing that I don't like about this. And it's the same thing with FINRA, but it is what it is. They're going to at least continue the same practice. They had an opportunity this year to dismiss a Howey case involving the same set of facts. They let it go through. And the Ninth Circuit, one of our leading federal appeals court, upheld it, that it was a violation of the Howey, criteria for an investment contract, meaning the criminals, and these were really criminals, were selling these, securities without registration as investment contracts under Howey. So just real quickly, and I don't think you were disputing this, I just want to kind of draw the practicing in the trenches lawyer, like you're practicing in the trenches venture capitalist, how we see this, which is, Paul Atkins actually has stood behind, in speeches, stood behind the Howey test. He's not looking for the Supreme Court to overrule that. He thinks it's a good enforcement tool. He's not looking to not enforce regulation BI, regulation best interest on broker dealers, not at all. He endorses these things. What he does want to do is, diminish the regulatory uncertainty that plagued the crypto and fintech space during the Biden/Gary Gensler, then head of SEC, years. He wants to clean it up. And boy, Jeff, when we were in the trenches during the Biden era, that's what we wanted, right? As lawyers, there's just no clarity. So part of the Biden technocratic improvements in the space is going to be this is what they want. This isn't Project Crypto. But they don't have the power to enact this, right? These are their working group pursuant to the direction of Trump in January of this year, 2 days after he took office or whatever. He gives a speech and then he does an executive order. It requires this working group, top cabinet members and top agency heads like SEC and CFTC, to prepare a report, making recommendations, setting forth a vision as to how to modernize with clear regulatory boundaries this crypto space, which has just been languishing in uncertainty, confusion, open hostility in the form of Gary Gensler. I'll give a quick anecdote on that later if we have time. We've got to rationalize. So what do they want to do? They want to make sure there are going to be 3 classes of digital assets. First asset class would be, let's call it DeFi, non-security digital assets, by which I mean things like, paradigmatically, utility tokens on a sufficiently decentralized network. What does that mean? We'll get into that hopefully. Number one. Number two, all other digital assets, with one caveat, which I'll get into, they're going to be commodities. Now, one strange thing is the US CFTC does not regulate trading in commodities. It regulates trading in commodity futures and similar commodity derivative instruments, right? Well, that's going to change, it looks like. And I'm not sure how that's going to require an amendment, obviously, a legislative amendment by Congress to the Commodity Exchange Act of 1936, because they don't even have that within their authority. It's commodity futures, obviously. So the current vision is for this to be added, and Chris, you're kind of smiling there. I'm not sure how they're going to do that exactly. It's not like the CFTC has experience in spot markets. It has tremendous experience in the futures and related derivatives markets for commodities, but that's the second class. That's going to be turned over to the CFTC. It's not like it's going to be a regulatory free-for-all. It's going to be turned over to, and then stable coins, right? That's, the Securities Act, a lot of people don't know this. Securities Act's already been amended to exclude from the definition of a security, which is where the Howey investment contract term includes, for stablecoins. Provided that the following definition does not include stablecoins as defined, right? It's got to be a particular, tied to the, fiat currency, the whole thing. So that's already happened. So that's their basic vision. It's an all of executive branch sort of effort. We just don't have time to talk about all the issues here because Jeff has got to get into his crown jewel performance here in the state AGs, which I'm looking forward to myself, as is Chris. It's the OCC, the banking regulators are involved. Little things like this have already happened. There was an accounting rule promulgated by the SEC staff, not the commission, called Staff Accounting Bulletin 121, which essentially kept the big players out of the crypto custody markets because it required them, if they're public companies, had to present their financials to the SEC to have this in their audited financials, which is you would take every custodial deposit as if it were like a bank deposit, a liability, but it's not, you're a custodian, right? You don't owe it, you're just holding. That's been rescinded completely. So it's an all of executive branch type of approach. It's systematic. There are 100 approximately policy and legislative recommendations in that report, which I suggest if you're interested in this US space, which may become a leader. I mean, I realize the EU has MiCA, which I believe also exempts DeFi type digital assets from its operation. Essentially, I'm not an expert on this, but that's my understanding from an outsider perspective. This may become kind of, a model for other jurisdictions to follow across the globe. I mean, not China, of course, but I mean, let's say Europe and places like that, UK, obviously. So we'll see what happens. but for lawyers here in the field, it's a great sea change. The anecdote I was going to tell, maybe I'll close on this, Jeff. The anecdote I was going to tell was Gensler was basically forced by our DC District Court of Appeals, federal jurisdiction, to start approving ETFs in spot commodity, crypto markets like Bitcoin and Ether started with that, right? Because they are kind of universally regarded in the industry as the two top tier tokens that are part of sufficiently decentralized networks, right? So they started with that. And the court said, hey, you keep rejecting these things. I mean, the Winklevoss twins were starting to do this in 2013, saying, I want an ETF in spot commodities that are in fact cryptocurrencies. Rejected, rejected, rejected. He was forced by the court because they're saying, hey, what's the principal basis for the distinction? How is this different? I mean,
it was
it's like he's
arbitrary
animus.
to
Exactly. I mean, that's what we all thought.
Yeah.
They forced his hand. So in 2024, he approves off the bat these Bitcoin and Ether spot commodity type funds. They're not really ETFs, they're ETPs. We don't need to get in that distinction. It's a constant confusion here, but let's just leave that to the side. Bottom line is he was forced to do that. I don't know if you remember this, Chris and Jeff. The day he sends out a personal announcement on SEC stationery about this, he explains it.
They were hacked.
Yes. Well, that was the day before. Correct. That was good. I remember that as well. That was good, Chris. But his official pronunciamento was just reeking with contempt and distaste. He couldn't help himself but say, hey, this is the preferred currency of terrorists, money launderers, ransomware criminals, and we do not endorse. It's unbelievable. So we have a sea change where you go from open inimicality and contempt to embrace of the potential for the good of our economy and for, cleaner financial structure, period. It's hard not to be a fan of that. Now, Jeff knows this. I don't think you do, Chris. I'm a bit of a skeptic myself for things like this. And with all due respect to you, I think AI is incredibly hyped in terms of, like the Yudkowsky stuff, the apocalypticism, the catastrophe. It's an unbelievable invention. Even to today, I can see that, right? Just in my own research and things, right? It's got to be treated with, some degree of skepticism when you get the results back. And I cannot tell you how many AI researches I've done that I know to be false. I mean, because of time, whatever. It's a developing technology. But I'm a skeptic about that in terms of the hype for sure. I probably constitutionally am a bit skeptical just about how far the crypto revolution is going to go as a business matter. Chris, you're closer to it. I know you're an optimist. But the bottom line, from the legal and regulatory perspective, whatever you say about Trump, he's put in place passionate advocates for the exploration to the maximum level of possibility of this potential revolution. He stands behind it, whether he's corrupted by his own interests and whatnot, is a separate issue. But there you have it. And Jeff, again, I don't want to step on your toes too much.
Yeah, I appreciate it. Yeah. And I see our new moderators come in, so I'll be quick here. Let me just say, I wasn't even going to mention too much about Trump, since both of you have, and because you're obviously advocates of the new approach toward crypto, I can't help but point out, as most people know, that if you look at Trump and his family, so far, at least on paper, they've probably made around $6 billion out of crypto so far. So I'm not so surprised that it's a completely deregulatory approach right now, but we'll get into that during the Q&A. You both did an excellent job. Thank you so much. All I want to really talk about is how when federal enforcement does have particular gaps, when it pauses what is necessary enforcement, or if it has a pivot that people are trying to catch up with, state AGs, state attorneys general, often become the de facto consumer protection agency, kind of last resort, and it applies in this area of fintech as well. One minute about what state AGs are, since we are talking with an international group here. The role of the state attorney general, they're essentially the chief legal officer of each of the states. You could look at their core powers as being, they're the counsel for the state. They bring civil enforcement like consumer protection actions, and in many of the jurisdictions, many of the states, they also have criminal enforcement. Unlike the federal attorney general, they're actually elected. So they have a sense of independence that certainly the federal AG doesn't have at all right now. And often they're of a different party from the governor. So you have this kind of reinforces the independence. So they represent the state, but they also represent all of the people within the state, and they can act in both state and federal courts. Now, what are the state statutes that we're going to look at? We'd look at what are called UDAP statutes, unfair and deceptive acts and practices. And this allows state AGs to prosecute fraud or deception, even when a product isn't technically a security. There's also, as Brian taught me a long time ago, there are these blue sky laws, state level security statutes that predate even the SEC itself, and they let SECs pursue unregistered or misleading offerings to state residents. I should also mention that AGs have parens patriae power. That is the ability, it's kind of a common law power that allows them to take action when they believe that the residents of their state, where they believe that their health, safety, or welfare needs to be protected, and they can bring actions to protect their own residents. And finally, when we're talking about procedural tools, the AGs have become very sophisticated in bringing multi-state investigations. These are informal arrangements where it's not just one state taking an action, but there's an informal arrangement where they can pool investigative resources, they can share legal advice, strategy, and make sure that they come up with a comprehensive settlement that is as good as they can get. This is a model that was perfected, I think, first with tobacco and then with the opioid cases. So let me just take a moment to talk about AGs as not just enforcers, but I guess as policymakers. There's been some comment about the Republican AGs taking one approach, Democratic AGs taking another, and that's very true. The Republican AGs just this month sent a joint letter to the SEC, and they said, when you're trying to figure out whether a token is an investment contract versus when it's being used as a payment or a stable value, be very, very careful. We need clarity, but don't define security so broadly that it's going to override state consumer protection and money transmission laws. This isn't really surprising. I mean, there's nothing that state AGs hate more than federal preemption. And so they are emphasizing that the states already have laws that regulate digital payments, stable coins, value transfer systems, because they have these money transmission laws that have been around ever since Western Union, right? And they've been able to apply that to the modern day fintech world. But still, litigation does remain their main focus, not just opining on policymaking. But they see litigation actually as a way of creating policy. So let's look at a couple of the cases that state AGs have brought. New York versus Gemini and Genesis. This centered on the Gemini Earn program, where investors lent crypto out for the interest. And the New York AG got involved and said that over 200,000 investors were misled and that they had concealed over $1 billion in losses. And that resulted in a settlement. Gemini, I know, ponied up $50 million for the settlement. And Genesis had to create a victims fund that could be worth up to $2 billion. Another one that is probably pretty well known is New York versus Celsius, where Celsius promised yields up to 17% while marketing its crypto product as safer than banks. Well, the New York AG sued for fraud and false advertising, and the FTC got involved as well. And the state AG case is continuing, but the FTC has already settled with a judgment of over $4.5 billion and a permanent ban from offering certain securities. New York also got involved with KuCoin and Coin Cafe. These were, again, the same thing, unregistered securities, excessive and undisclosed fees, and those have reached settlements. And it's not just New York. California, you've mentioned Robinhood. California brought a case against Robinhood Crypto and alleged that users were misled about liquidity and withdrawal restrictions, especially during crypto volatility. and they settled for $4 million and stronger disclosure controls. And then again, mentioning multi-states, because the states are acting together now. Nexo, I think, is a good example. 10 AGs got together, and that resulted in a $24 million multi-state settlement over unregistered interest-bearing crypto accounts. So I think these cases show that the AGs are acting where federal agencies either were uncertain or they were just slow to respond, especially on unregistered lending and deceptive marketing. And please note that you probably heard New York and California. Those are the two main states. And that's not an accident, because they're the ones that can handle these complicated cases. They've got more resources than the other states. And even in multi-states, they tend to be the leaders. So I think this shows why state enforcement matters. They've got speed and flexibility. They can act faster than the feds. They're focused on consumers. They target deception, unfair fees. These are practical harms that consumers feel first. Again, they're filling the void. Let's say that the SEC or CFPB pull back too much. The AGs can come in with their consumer protection lawsuits. And these multi-state settlements often pave the way for federal policy. I think the last thing I'd say on that is that the AGs can often sidestep many of these federal debates that Brian and Chris were talking about. And the way they look at it, AGs, they're focusing on conduct. They're not focusing on code. So there is this federalism dimension. I think it's effective. States are renowned as being laboratories of democracy. They're also laboratories of enforcement. And in closing, I would just say that Congress should be involved. These federal agencies should be taking the lead. And we should think of the state AGs as the fire brigade, not as the building inspector. But they are a good backstop when the feds don't take action. So with that, I turn it over to Alan and see if we have any questions.
Thanks very much, Jeff, and thanks very much, Chris and Brian. Sorry, my apologies for being late. I've been teaching, and Iris Chiu's gone off to teach as well, so we're handing over. Very interesting. Just picking up a few points that have been made that I've picked up. With this issue of state laws and the, let's call it, the pushback against federal preemption, is there a risk of, let's call it, a flight to the weakest states, so sometimes called a race to the bottom, so that certain individual states will go out of their way to try and attract, let's call it, various transactions and institutions that wouldn't be countenanced in, say, New York State?
Yeah, I'll just quickly comment on that. And I think in crypto, there is some evidence that some of the companies would like to take advantage of some looser state enforcement. I think Wyoming has become a pretty popular crypto base. But there is what we call the California effect. And in this case, it should be the California-New York effect.
Yeah.
Most of these investors cross state lines. And so if a California or a New York AG believes that any of the investors in their states have been harmed from misleading or deceptive advertising or statements, they're going to take action even if the bulk of the victims are actually in other states. But that also is a very good argument for New York calling up the consumer protection people in the other states and saying, you know, we need to come together. We need to have 10 or 12 or 20 states all come together and take action regardless of what state the company is domiciled in.
Thanks very much, Jeff.
Can I just...
I was going to just move on to Brian and Chris in a moment, just to say if any of the audience want to add any questions, please do it in the chat and we'll pick those up. Sorry, Chris.
Oh, no, I'm sorry. Sorry for stepping on you. Jeff, one thing I would say, and Alan, the nature of fintech is such, I mean, this is just comporting with what Jeff just said, that it tends to be a nationwide operation. So, you know, that kind of forum shopping for where you want to conduct let's say, a little bit shady business or something, may not be as prominent in this field. One other thing I wanted to say, and Jeff, you know, I'm a huge fan of AGs filling in regulatory lacunae, obviously. Mm-hmm. But you do realize, and I don't think this is as bad as it sounds, under Project Crypto, part of the plan is to federally preempt all regulations relating to the crypto space. Okay, now, two things. One is that there is precedent for that. That's not like a Wild West type of an approach here. Remember, in 1996, we had the National Securities Markets Improvements Act, which basically it kind of revolutionized private placements in a way. Private placement, regulations basically were subordinated to Reg D. It took over the space. What's a covered security? There's some exemptions. There is precedent for that kind of regulatory, reach, which was not considered overreach then, and it's worked well, blah, blah, blah. I guess what I would say with respect to the crypto space, remember that even with that National Securities Markets Improvements Act, always left open was anti-fraud actions by the various states through their AGs or otherwise, right? And that's an interesting point here, because even if, and you probably won't like this, but even if there were federal preemption limited to the crypto space as to regulation, registration, licensure. Remember, New York and California have licensure for Bitcoin brokers, that's a complication from the federal perspective. So even if that goes through, and it's definitely one of their stated desiderata as Project, Crypto, I'm not sure it's going to change things very much, because always in these federal preemptions of that type of regulation, the states are free, obviously, in the interest of their parents' patriae kind of activity, to go after the fraudsters on their anti-fraud statutes, right? Remember, Sam Bankman-Fried wasn't held up and convicted on the basis of selling unregistered securities. It was money laundering and wire fraud. I mean, they charge him with securities fraud and commodities fraud, but our wire fraud statutes are sufficient to convict an actual criminal. You know what I mean? So I don't think this is going to hamper. I don't think so. You're the AG expert. I don't think that even if that preemption goes through as they desire it to go now, I don't think this is still going to stop the AGs from doing what they need to do.
No, and I just want to say I totally agree. I think what the AGs that expressed their concerns were saying is just be careful. Be careful. Don't preempt the state laws that we have used effectively, because we've been enforcing money transmission laws and other fraud laws for a long time. So just be careful as you devise these federal rules. But
absolutely, and that's the way I read that letter. Yeah, and that's the way I read that letter myself.
Okay.
Sorry, just going to ask Chris, is anything you want to add on this matter, on this issue of state versus federal?
I agree completely that the AGs are going to continue to be active in the space on the anti-fraud basis. I do think that preemption is, for operators and for companies, the preemption is generally favorable and helpful to assure that you're not going to face a kind of rogue AG saying that something's a violation of law when it might not be, and there are problems with the New York State registration system around bit licenses that they issue that have caused some trouble for companies, and companies don't like them and definitely want to try to avoid them. Some do avoid New York based primary operations for that reason.
And just following on from that one, which is a related question in many ways, in terms of financial stability and contagion, the worry is that something will go wrong, has gone wrong in a relatively small, say, stablecoin area or one of the other cryptos, and it becomes too big for the state to handle and has to be, let's put it, dealt with, including, let's put it, bailouts at a federal level. I don't know to what extent you've been looking at that.
Well, I mean, if you look at, Luna being one of the most prominent situations where it was an algorithmically based U.S. dollar focused stablecoin, which depegged because of the way that trades got imbalanced. And it wasn't backed by treasuries and by like core bond securities on a one-to-one basis, the way that most stable coins are. The argument that was going to be too big for states to handle, I think, is a realistic one, and that the Feds definitely got deeply involved in that.
Any views from Jeff and Brian on that?
No, the only thing I would add is that I agree that some of these are so big that the feds are the obvious regulator. But just as a point of reference, I would say that keep in mind that the AGs are beefing up their practices. It used to be just not that many years ago. There was very little expertise in this area in the AG's offices. I think that's changing. Obviously, New York and California are the first, but keep in mind that there are over 14,000 deputy AGs in the country. And if just a small percentage of them develop this expertise and start to take action, they can be very, very helpful. But I think we've kind of set it out that, look, the AGs are still the backstop. The feds are the ones that have got to do this.
Thanks very much. Brian, was anything else you want to add on that before we sort of...
No, I agree with both Chris and Jeff on that. I don't have nothing to add on that.
No, great. Well, sorry, someone was going to say something. No, I was going to say we're pretty much coming towards the end of time. I was going to ask whether there are any sort of final words that either Jeff or Brian or Chris want to make before we close.
I mean, I'm happy to jump in and say that, you know, the prevalence of innovation in the space over what I do think was an overly regulatory and anti-innovation regime under Genslerism at the SEC is a breath of fresh air. But I do think it's critical that we find those areas where you know, real fraudsters and criminals are rushing in because they perceive that there will be less possibility of consequences. I do think it's important to have these, you know, variety of regulatory regimes that are protecting consumers and driving towards better behavior. I think that that's best for the marketplace.
And that's not going to change under the current environment, Chris, in terms of where the SEC, that's what I was trying to emphasize. Under the new SEC, under Paul Atkins, he's actually put it this way. It's kind of his mantra. If it's within the jurisdiction of the SEC and it involves lying, cheating, and stealing, they're going to go after you. And it could be under wire fraud, it could be under anything. If it's within the jurisdiction, they're going to go after you. So I don't see a complete, like some people talk, a complete abandonment. Quite the contrary. They want to regularize the markets. They've been highly irregular, unpredictable, innovation stifling in part. I'm talking about the Gensler regime, obviously. And, you know, to me, Alan, this is a breath of fresh air as a lawyer.
Really let's just hope that all of this work that's going on, Project Crypto and things like that, that they are sensible enough rules that they can last beyond, you know, the next 3 years. We don't need to continue to have the whiplash.
Exactly. Totally agree.
Well, all I can say is thank you very much for the wonderful contributions. I'm only sorry that I only heard about half of them from Chris and Brian, and also Jeff, and giving a wider sense in terms of, amongst other things, the interaction between federal and state regulation, and the role of preemption, and the important role of the state AGs and their deputies. I never really thought of their deputies. I always thought of the state AGs. And this issue of the role that was brought up, and obviously an area that's worth developing, of self-regulation and FINRA, which is one that's close to my heart. But thank you very much. It's been very, very interesting, and I've learned a lot, even in only in half an hour. It's great to see everyone, and thanks very much, and we will close at that point. Thanks a lot.
Special thanks to Chris and Brian.
Thank you all.
Thanks, everybody.